Hi, let's break down the different remedies for breach of contract.
Breach. A breach of contract occurs with the failure of one or both parties to perform. This may give rise to one of the parties suing the other for breach of contract. If the party does not fulfill his or her contractual promise, or has given information to the other party that he or she will not perform the duty as mentioned in the contract, or if by action and conduct seems to be unable to perform the contract, the party is said to be in breach. Breach example. An example of breach would be a buyer that gets cold feet right before closing and simply refuses to buy the house with no cause. Imagine if the seller has moved out of the house and even made specific upgrades prior to closing as part of the buyer's demands. If the seller sues the buyer could be held liable. Remedies for breach of contract. A method of securing a remedy for a breach of contract is to seek legal intervention by the courts. Remedies for breach of contract include specific performance, award of damages, rescission, and compensatory damages. Specific performance. Specific performance is when one party demands that the other party perform as stated in the contract. A remedy of specific performance may be resolved by taking the other party to court with the goal of making the other party honor the terms of the contract. With breach of a real estate deal between a buyer and a seller, this often is an argument about right of possession and ownership of the property. The prevailing party of the lawsuit would win the right to own the property. So, if the seller was suing the buyer, then the buyer would be forced to buy the property. Or if the buyer sued the seller, then the seller would be forced to sell the property. Keep in mind that if the specific performance forcing a seller to transfer ownership of a property would cause severe hardship to a defendant, the defendant normally prevails. As such, it is rare for a judge to order a seller to sell and vacate a property even when the seller is clearly in breach. Liquidated damages. Liquidated damages in a real estate purchase and sale agreement is the retaining of the earnest money deposit. Most real estate purchase contracts specify how much of the earnest money could be retained by the seller as liquidated damages should the buyer fail to perform in the purchase of the property. For example, if the buyer makes an earnest money deposit of $5,000 and refuses to buy the house without cause, the seller may have the right to retain the $5,000 as liquidated damages. Keep in mind that this may be better in theory than in practice. Per the process and procedures of releasing earnest money, a seller who attempts to retain the earnest money from a buyer when the buyer refuses to sign a release of that money over to the seller may end up tying up their house legally, keeping them from being able to sell the home to another buyer while this situation is in dispute. Most brokers will not release the money unless both parties have agreed. So this often leads to the parties going to court to resolve the issue. And the reason that the dispute may hold up another sale is that title insurance may not be issued if the property is in legal dispute. Therefore, this remedy tends to be reserved when substantial sums of earnest money is involved, making the struggle to retain a larger payoff worth the delay and trouble. Rescission. Rescission is the court rectifying that the parties be made whole, matching how they were before the contract was entered into. Rescission is when the court mandates that both parties are positioned back to where they were before when they entered into the contract. Rescission is the unwinding of a transaction. This is a position forced through court action. The court may decline to force rescission if substantial performance can be shown in implementing the contract, even if it was only partially implemented by one or both of the parties. Compensatory damages. Compensatory damages are damages equal to the amount lost. Compensatory damages do not include punitive damages, which could also be awarded. Sometimes when a party is injured, usually monetarily, by the breach of a contract, the injured party may be awarded compensatory damages for this injury. The amount of money awarded is for the sum of the loss. This may also be awarded as expenses for lawyers and court fees. However, compensatory damages do not include punitive damages, which also could be separately awarded. The losses must have been unavoidable. If the non-breaching party could have prevented the losses but failed to do so, it will disqualify them from receiving compensatory damages. This is known as the doctrine of avoidable consequences.